but the Supreme Court case regarding police pursuits, that evidence that was presented in the Supreme Court weighed on flatly was contrary to what it was that the plaintiff said happened in that circumstance. And that is a very narrow case where that was the circumstance, and I believe the cases cited by the defendant involved a security camera in a courtroom, and the court only then considered whether the amount of force was unreasonable. And, you know, there could have been other facts that aren't seen in that video. And in the video cited in the District of Oregon case that was proffered by the defendants. But the court only weighed that in terms of what was the force used in that moment. And if
the example that you are describing might be a little bit different than the one I have in mind. What you're describing is that there may be a reasonable difference of opinion about what happened when one both looks at that video and considers the declaration, because maybe the video doesn't tell the whole story. But if we do have a situation where the video does tell the whole story as far as what specific facts that we're looking at, and it flatly contradicts the declaration, in that situation, can I disregard the declaration?
I would still say that is a question for a jury. It is not a question of law. It is a question of fact, and one that at this early stage in litigation cannot be decided by the court. But you do bring up what would be my next point on this. Not everything that is in the video is dispositive. In fact, we cite in our, or testify to in our declarations that there's a lot that happened before this event. We talk about as well the course of dealings with Mr. Gibson and the city of Portland. Much as the defendant would like us to only focus on moments where Mr. Gibson is yelling, putting down your weapon, not less than 10 seconds before that was he yelling, fight, 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 and let them fight. Those words are part of the MO of Mr. Gibson. He yells and screams and cajoles and conspires and directs people to fight. And then he gets to claim, or then he attempts to claim that he had nothing to do with it. When I think we can all see from the video and see from common experience and from people who declare to have been there and who also have watched these things, that is not the whole story. And indeed, our declarations and the facts that are being brought in the criminal cases against the defendants and not Mr. Willis, but the other named defendants in this case, there's a finding that Mr. Gibson, in coordination with 5 or more people, engaged in tumultuous behavior, unlawfully tumultuous behavior. Indeed, there are other crimes that we think were committed that day. We're not the district attorney's office, so we don't get to make these charging decisions. But as we list, I mean, we could see, and we saw in this video, we saw things that could be alleged as a riot, disorderly conduct, unlawful possession of body armor, harassment, menacing, reckless endangerment, assault in the first degree, and assault in the second degree. Some of those were charged, of course. And that, of course, goes to the first problem of our analysis, that this is not, in fact, protected speech. Just because somebody is yelling about nonviolence while punching somebody doesn't make it protected speech. It doesn't mean that if Mr. Gibson is aiding and abetting criminal activity while yelling about peace practices, it doesn't mean that he didn't, in fact, aid and abet a criminal act of violence.
Let me ask you about 2 of the specific claims for the negligence claim and the trespassing claim. It's my understanding of the plaintiff's complaint that the plaintiffs are not alleging that Mr. Gibson himself personally, physically committed those acts, but that he is liable for those acts because he encouraged, organized, directed others who did commit those physical acts. Is that a fair characterization of those two complaints?
That is, Your Honor, and although I would add that maybe this is a circumstance where the judge could look at the evidence that's presented, but I seem to have witnessed Mr. Gibson, in fact, push and enter onto the property of Sideride in the course of the initial interactions here. But indeed, in substance, Mr. Gibson did and was the but-for cause of all four of the claims that we made.
And that is exactly where my questions are going. You argue that he is a but-for cause, but can you prove that if I were to conclude, and I'm not saying I am going to conclude this, but if I were to conclude that all of this would have happened if not for Mr. Gibson, is he still a but-for cause in this case?
Oh, I'm sorry, can you restate that question?
What if I were to conclude from the evidence that it is clear and that no trier of fact could find otherwise, that all of this would have happened if not for Mr. Gibson?
Well, and the question is, can we still find Mr. Gibson liable? Well, Mr. Gibson, and again, I need to emphasize that not everything that's on the video is what's dispositive in this matter. Mr. Gibson has participated, has encouraged, has conspired with other people, and indeed, as defense counsel mentioned, this wasn't, in fact, one of the Facebook groups or Facebook events that Mr. Gibson was promoting. This tends to show that Mr. Gibson isn't only organizing these events on Facebook. There is another group, and indeed we have certain frequent flyers and usual suspects in Mr. Gibson's rallies who show up consistently wearing body armor with weapons, inciting riots, and assaulting people. And so there is more, and we allege this in our declarations as well as in our complaint. There's more facts that happened than just what's in the video. So if the court were to conclude that this would have happened, this particular event on May 1st could have happened without Mr. Gibson, I think there's still other evidence that put the stream of causation, or puts Mr. Gibson at the head of the stream of causation here.
And I can see that with respect to the other two claims, the intentional infliction of emotional distress and the intentional interference with economic relations. But you think that that is also the situation with the negligence and trespass claims?
Yes, Your Honor. And we can see that through, indeed, the video that the defense counsel seems to provide to suggest that people were going to go do that anyways. When, in fact, nothing happened until Mr. Gibson showed up. They were waiting for him. It's as if, infantrymen were bad-mouthing their general. Ultimately, they followed their general's command. The general doesn't need to fire a shot to, in fact, cause a war or cause a battle. So, I think it's immaterial whether or not the other folks have negative views of Mr. Gibson. Ultimately, he is their cover. And that is what we allege to be Mr. Gibson's ultimate goal with doing these actions. He live streams these videos, he fundraises off of these videos, and he makes these videos with the explicit purpose of there being a riot that he encourages, starts, aids, and abets, and conspires to create. And so I do think that he is still ultimately liable in this class. And so I would just like to, again, just emphasize that I think what is happening with the defense's argument is, in fact, accusations to the While he's saying that Antifa or anti-fascists or whoever it is that show up to counter Mr. Gibson's events are the people who cause violence. That is not what happened that day. And it's clear as day in the video that this started. The shot fired at Lexington was when Mr. Conti fired his pepper spray into the crowd, crossing the property line into the Cider Riot seating area. And that was all inevitable based on what Mr. Gibson brought into being that day. And the conduct that was displayed that day is being tried, was indicted for criminality. Thus, the defendants do fail on the first prong, the initial prong, the threshold question of whether or not this was protected speech or not. It was not.
And I am correct that it is your argument that I have to look at only well-pled allegations in the complaint to determine whether or not the defendants have met their burden on the first prong.
That is correct, Your Honor. Yeah. And then as the Legislative Council explained it handy, that it is the plaintiff's burden to then provide affidavits that underlie the allegations made in the complaint. And that is the extent of the, if you want to call it an evidentiary matter. If the defendants wanted to provide additional declarations, that is countenanced, but it's not what's dispositive for a prong two. So, if the court has any additional questions or would like us to brief additional issues, we would love to take that opportunity. Mr. Davidson unfortunately had a family matter, so we couldn't be here today. So if there's something I missed that Mr. Davidson would have wanted me to say,
I think I have all the briefing I need, unless there's an issue that has come up today that either party wants an additional opportunity to brief. I would consider that. Mr. Chavez, can you think of anything?
Not this time, Your Honor.
Okay. Well, Mr. People.
Yeah, I'm prepared to show the court the shot from Lexington, the woman throwing the drink before the pepper spray. If Your Honor wants to see if Your Honor has the references in the...
Sure, no, we've got a bit more time. If you want to use this as sort of your rebuttal time, you can do that.
And with regard to the question of prong one, I didn't hear a clear answer from Mr. Chavez, but we are allowed to show under 31-150 that the incident arose from conduct in furtherance of the exercise of the constitutional right of petition. And so when the court, when the legislature gives people the right to show how the conduct arose, it's necessarily going beyond the allegations. That's for prong one, that's all I would say. With respect to the question of the glass of beer, I've got 3 different views of that. So one of these out of work.
Grab my cup for me.
This is at 6, that's 13, for example. The first one.
Thank you.
Over on the side there, and the girl in the red sweatshirt is the one we're talking about. They didn't see her throat. We saw the pepper spray start afterwards. Sort of an escalation. There's this feeble little spray from the demonstrator side, and then somebody has a real powerful bear spray kind of thing that goes there. But that was the escalation relating to the pepper spray that I was trying to show before. With regard to Your Honor's question about additional briefing, I responded in considerable detail to every crime that Mr. Chavez thought up. Your Honor has thought up another one, aiding and abetting. I would like to research the issue of how aiding and abetting plays out in the First Amendment context, because up until today, there was no suggestion that was the underlying criminality. So I will, with your Honor's permission, file an additional sort of bench memorandum on that in a couple of days, maybe next week, next Friday.
Okay, let's take a look at scheduling, because I also want to make sure that Mr. Chavez has a chance to respond to that if he wants to. So let's take a look at scheduling. If we are going to do that, I'm going to delay my ruling more than 2 weeks. Well, maybe I won't have to do that. So if Mr. Buchel were to file that bench memorandum by Friday,